Hi, in this video, we will be discussing the salient features of Presidential Decree 1612 or the Anti-Fencing Law, which took effect on the year 1979. So according to the 1996 decision of the Supreme Court in the case of De La Torre versus Comelec, fencing is a crime involving moral turpitude. The actual knowledge of the fact that the property received is stolen displays the same degree of malicious deprivation of one's rightful property as that which animated the robbery or theft, which by their very nature are crimes of moral turpitude. So what is fencing? Fencing is the act of any person who, with intent to gain for himself or for another, shall buy, receive, possess, keep, acquire, conceal, sell, or dispose of, or shall buy and sell, or in any other manner deal with any article, item, object, or anything of value which he knows or should be known to him to have been derived from the proceeds of the crime of robbery or theft. So to be liable for fencing, it is not necessary that the intention of the offender is to gain something for himself. It can also be for another person. And the acts prohibited by this law are the act of buying from anyone, receiving from anyone, possessing, even if you did not stole it, but you only came into possession with it because the robber sold it to you or gave it to you with the knowledge that such good is stolen. The act of keeping, the act of acquiring in any manner unless it is legally acquired, which will further be discussed later on. The act of concealing, the act of buying, the act of disposing. Again, with an exception that if you are a licensed or you are permitted by the state to sell it, then you may, which will also be further discussed later on. So to be liable for fencing, the offender buys or otherwise acquires and then sells or disposes it of any object of value that he knows or should be known to him to have been derived from the proceeds of the robbery or theft. So, who is considered a fence? Fence includes any person, firm, association, corporation, or partnership, or other organizations who or which commits the act of fencing. So a fence is an individual who knowingly buys stolen goods in order to later on resell them or to profit from them in any other manner. The officers of these juridical persons mentioned are liable under this law if the fence is a partnership, firm, corporation, or association. Such officers are the president, it may be the manager, or any other officers who knows or should have known the commission of the offense, and each of them may be liable.
Hi everyone, I am Alifa Jana Pasagi, and in addition to what Ms. Butawan has discussed, to constitute fencing, the following elements must be present. 1. That a robbery or theft has been committed. 2. The accused who took no part in the robbery or theft buys, receives, possesses, keeps, acquires, conceals, sells or disposes, or buys and sells, or in any manner deals in any article or object taken during that robbery or theft. And 3rd, the accused knows or should have known that this thing is derived from that crime. And lastly, he intends by the deal he makes to gain for himself or for another. Here we must also bear in mind that under PD 1612, fencing is a distinct crime from theft and robbery. And for a charge of fencing to prosper, it must first be established that the article subject of the alleged fencing has been derived from the proceeds of the crime, or the theft or robbery. It must also be pointed out that the law on fencing does not require the accused to have participated in the criminal design to commit or to have been in any wise involved in the commission of the crime, which is the robbery or theft. Neither is the crime of robbery or theft made to depend on an act of fencing in order that it can be consummated, while the crimes of robbery and theft, on the other hand, it is separate and distinct offense. The state may thus choose to prosecute the accused either under the revised penal code or under PD 1612, which is the anti-fencing law. So the presumption of fencing, the mere possession of any good, article, item, object, or anything of value which has been the subject of robbery or thievery shall be prima facie evidence of fencing. The presumption does not offend the presumption of innocence enshrined in the fundamental law. It only shifted the burden of evidence to the defense, and the burden of proof is upon the defense to overcome the presumption. The following are the penalties for the persons liable of fencing. A penalty of prison mayor if the value of the property involved is more than 12,000 pesos but not exceeding 22,000 pesos, and a prison mayor in its maximum if the value of such property exceeds 22,000, adding 1 year for each additional 10,000 pesos. A penalty of prison correctional in its minimum and medium periods if the value of the property involved is more than 200 pesos but not exceeding 6,000 pesos. Prison correctional in its medium and maximum if the value of the property robbed or stolen is more than 6,000 pesos but not exceeding 12,000 pesos. And a penalty of arresto mayor in its medium period to prison correctional in its minimum period if the value of the property involved is over 50 pesos but not exceeding 200 pesos. Arresto mayor in its medium period if such value is over 5 pesos but not exceeding 50 pesos. And lastly, arresto mayor in minimum period if such value does not exceed 5 pesos. Here in prison mayor, the total penalty shall not exceed 20 years, and in such cases the penalty shall be termed reclusion temporal, and the accessory penalty pertaining thereto provided in the revised penal code shall also be imposed. All stores establishments are entities dealing in the buying and selling of any good, article, item, object, or anything of value obtained from an unlicensed dealer or supplier thereof shall, before offering the same for the sale to the public, shall secure the necessary clearance or permit from the station commander of the integrated national police in the town or city where such store, establishment, or entity is located. Here, the Chief of Constabulary or the Director General, the Integrated National Police, shall promulgate such rules and regulations to carry out the provision. Any person who fails to secure the clearance or permit required by this section, or who violates any of the provisions of the rules and regulations promulgated thereunder, shall, upon conviction, be punished as a offense. The clearance or permit to sell, use, to sell used second-hand articles under Section 6 of PD 1612 is required if the clearance stated in Section 6 is only required if several conditions are met, which are first, that the person, store, or establishment or entity is in the business of buying and selling of any goods, article, item, object, or anything of value. Second, that such thing of value was obtained from an unlicensed dealer or supplier. And lastly, that such thing of value is to be offered to sale to the public.